Lucy Letby could be forced to appear in court and face victims' families when she's sentenced later this afternoon.
Well, the killer nurse is predicted to be handed a full life term, could be compelled to attend the sentencing if she continues to refuse. Let's find out, though, whether or not she should be compelled. Tana Adkin is the Vice Chair of the Criminal Bar Association. Good morning to you. She says she shouldn't have to appear because it could disrupt the dignity of the court process. But Mark Johnson says she absolutely should be in the dock today. May I start with you, Tana, because it's clearly a highly emotive story. We're talking about many dead babies, many bereaved families. And a lot of people cannot understand the distinction between the trial, where she was compelled to attend, and the sentencing, where if she doesn't fancy it, she has the option of opting out. Why is this different?
Well, I think there is a distinction because the defendant has a right to be heard in a trial, and in any other hearing, a defendant can forego that right, and therefore it can be taken into account against them. But having a precedent where we force defendants to attend for their sentencing hearing could be an opportunity for disruption, and causing disruption to sentencing hearings is really what the court will not allow. To disrupt the process would be the worst thing that could happen. And Lucy Letby will be sentenced whether she is there or not, and she'll be sentenced without fear or favour or emotion by the judge according to law. We cannot allow emotion into our courts. Indeed, juries are directed not to involve emotion in their deliberating. And whilst it's a tragic case, and my absolute heart goes out to these families, we must not allow the court process to be disrupted in any way. And forcing defendants into the dock doesn't help. What are we to see? If a defendant doesn't show any emotion, does that mean there are no emotions? It's a very difficult situation.
Well, Mark, Sir Robert Buckland, who is the former Justice Secretary, he says, OK, let her sit in her cell, but pipe in everything that the families have to say, pipe that audio into her cell and make her listen to it. Let her kick off if she wants. That sounds a pretty good idea to me.
Well, I mean, the polarisation of this issue and over-politicisation is a room for politicians to just win votes for the next election, as far as I'm concerned. And you've had 30 justice ministers in the last 12 years come out with all of this rhetoric, etc. Where I'm at with it is that when we commit a crime, if a crime is committed, and I've committed crimes myself, by the way, is everybody is accountable for their behaviour, like everybody. And part of that accountability is to be sat in the courtroom in front of a judge and getting a sentence. Now, for people who want vengeance, etc., which that isn't me, I want justice to occur. The public have lost their confidence in justice, and this is part of the reason why they've lost it. Court is one place that you go as a criminal. Or as somebody who's committed an offence, where every single circumstance gets looked at, and that must happen. So we've got a situation today beyond this issue, this polarised issue of this murderer. You've got a situation today where there is a severe neglect. So from committing crime to the length of time that it takes, for the police issue around getting evidence and stuff correctly, to then going into the courts, to then being sentenced, and then whilst on a sentence, experience this severe neglect. So 22 hours a day, people are locked up now. 4 in 10 people are getting released from prison without anywhere to live. There's no confidence in the justice system as a whole.
Well, that's an important point, isn't it, Tana, that the whole part of justice is justice has to be done, but it also has to be seen to be done. And you talk about perhaps a precedent being set for disruption to the process. But this is a key part of the process, isn't it, to have that perpetrator convicted in front of the victims? I mean, sentenced.
Yeah, well, she's been convicted and she will be sentenced. Whether she sits there to hear the sentence or not, to my mind, is not the most important factor. The most important factor is that a jury have spent their time listening to all of the evidence fairly and properly, have come to their impartial decision. The judge will come to their impartial decision on sentence, and whether she wants to listen to it or not, she will be sentenced in due course, and that process must not be disrupted by anyone. Defendants in trials and other court hearings and other sentences who don't turn up, they are not allowed to disrupt the court process. It carries on regardless, and she will be sentenced. That sentence will be passed fairly and properly in due course, and whether she is there or not, it will happen.
Tana, it's interesting to hear you talk as a professional about the way things should go, the process should work from your side of things, and the dignity of the whole court process. But Mark, also, from your point of view, having appeared before judges, having appeared before juries, you're a former prisoner, you're now founder of what's called Lived Expert, but you both see, Tana, I suppose what I'm trying to say is that for justice to be effective, it's got to be seen to be correct, it's got to be seen to work. And Mark is saying this is one of the ways it works, by actually having relayed to you just how bad you have been and the impact of the crime you have committed on people.
Well, Lucy Letby will have to hear what her sentence is, whether she sits there and listens to it or not. I mean, she could simply sit in the dock and close her ears and her mind to it. But we cannot force human beings to accept their failings. We hope that they do come to an understanding and an acceptance of their failings and where they have committed crime. In fact, that is, of course, a purpose of the criminal justice system, but we cannot force people. And it may be that it takes some time for people to come to that acceptance and that understanding. And it's not something, I'm afraid, we can force on human beings. My concern is that by forcing this, it will cause disruption to an already overburdened criminal justice system with the delays that there are. And we want to have justice seen to be done, but done as effectively and as quickly as possible.
Mark Johnson, I don't know if you ever, whilst you were in front of judges, also had to have impact statements read out to you from some of your victims. What was the impact on you of that? I mean, did it make you feel bad, uncomfortable, and would you have avoided it if you could have?
Well, I mean, my crimes were quite a long time ago, right? But and actually, when I committed those crimes, I was a drug addict. So there's a lot of mitigating circumstances. I'm not saying that. What I'm saying is everybody's accountable for their actions and should hear the impact directly as possible from the victim. And that's morally right. And I think the public are really behind this, by the way, beyond the politicians and stuff, just because of our own sense of morality. But you've got this issue within criminal justice where justice is distant. So the courts, it might be convenient for the courts and everybody gets paid in there to have this process carried out quietly, etc. But the public have lost confidence in the justice system, and part of that is to see people. I work with people in prison that are in there. They come out, even lengthy sentences, with the same deluded beliefs that they had when they went in there, because their behaviour never gets real scrutiny and behaviour. And I don't mean punishment or as I said, their vengeance or prying and voyeurism, etc. I mean real inquiry about their deluded minds. So I was in recently, a guy, he got 10 years for burglary, and he believed that he didn't have his crimes were victimless. And I said to him, do you know that there's no such thing as a victimless crime? And it was like the first time that anybody had ever challenged him with his behaviour. And this guy had been in there 5 times. And the public know that the reconviction figures kind of tell the truth there. So the public know that actually nothing is actually being done at the biggest opportunity. In the court, in that sentencing, this is where it gets everything gets weighted. Everything is weighed up. Mitigating circumstances, but also the the justice system's opinion about, who is responsible for what, and everybody gets to see it. That's the most important thing for the victim. Everybody gets to see, because I'll guarantee you, if we went to a referendum today about the death penalty, because of the media polarization and about these 1 or 2 cases, the public would want to bring back the death penalty. I've actually had 4 debates over it. Not in the recent sort of recently about it. So this is one way that we open it up, that the public will say, no, actually, that's right, that somebody is held accountable. They're made to listen to it. And then and basically everybody can try and get on and heal or move on and have some level of confidence in it.
Guys, thank you both very, very much indeed. Very interesting to hear from you, Tana and Mark. Thank you very much.